Good morning. So thank you very much for the opportunity to come and speak to you for the LAWPRO update. First of all, Dan sends his regrets. His agenda basically does not permit him to be here this morning. He regrets that, but we're bringing messages from him and important message. So I will be changing the role a bit for those who have seen me in the past. I'm not here to scare you this morning. I'll leave that to my colleague, and just so that you have that. But we'll go through basically a review of 2023, give you some claims trends to show that we are still getting claims. Then we'll talk about what's brand new for us, social engineering, brand new for you. And we'll also have a reminder on admin dismissals. I just checked, and we already have, ahead of Monday's start, we already have 35 claims that are in. So people are starting to realize, which is good, starting to deal with it, but we need to address that. Admin dismissals last time costs LAWPRO $10 million. And when you consider that your premium is based on the claims we pay, it's all in our interest for us to get on top of these things. And we're quite concerned as to what avalanche is waiting for us in this. So let's just start off. Basically, we invite you to go take a look at our annual report. It's on the website. There are a number of very interesting things, but basically, we hope that you're going to realize that the program is well maintained for you, and that we have everything in place that needs to be in place to fully support you in your practice. We do insure over 31,000 lawyers in the primary program. We also have, in addition to that, over 21,000 that are retired, left the practice, and have some coverage. As you know, the runoff is automatic, no payment, no information. You get an automatic $250,000 for a lifetime, but if you want more, then you can buy that up. We also insure over 1,700 firms with excess, so over and above the 1 million. We do offer excess insurance up to an extra 9 million, so 10 million in total. And we have mostly solos and smalls. The big firms can afford to go to Lloyd's of London, but the solos and smalls are typically our clients. Do we receive claims? Yes, we continue to receive claims, and as you can see, the trajectory is on an upward trajectory. Somewhat concerning, but also remember that every year we add 1,000, 1,200 new lawyers. So when we do the analysis per 1,000 lawyers, it's about constant. So lawyers aren't just getting worse. There's just more out there. So that's kind of the good symbol, except that, we're now getting over 3,000 claims a year. We presently have over 5,000 files that are open that we're dealing with. So very busy claims counsel in our offices. Where do we see claims? Again, real estate and litigation are 1 and 2. They usually fight for that. Lately, with the courts closing down, litigation has slowed down a bit. The worrying trend for us is, if you look at the purple line, the wills and estates, it is going up. And when you're looking at the demographics, more people are transferring sizable estates. And whenever there must be one beneficiary who's not happy. And of course, it can't be mom and dad didn't inherit me. It must be the lawyer screwed up. At least that's the claim we get. So just be mindful when you're dealing with those areas. All of these slides will be provided to you on the website, so you have them there. The good news is that basically your premiums have been pretty much stable. We've been able to long-term predict where we're going. If in fact you can see your premium is actually lower than it was 10 years ago. Try to find another product where you can say that. And in fact, much less than when I started practicing, when we luckily paid $5,600. So much better. Also, people are concerned about filing a claim. I don't want to file a claim. It's going to be a deductible, going to be a premium. 34% of all claims are closed without any expense whatsoever. And if it's closed without an expense, there's no deductible, no levy surcharge. And so the good news is filing a claim doesn't mean there's a financial penalty to you. Only when we do put out money, then we have the option of being able to, of then calling on a deductible or a payment. Why do we see problems? Again, the same thing, communication number one. And I find that very curious that for lawyers who boast to be good communicators, that is the main reason why we have problems. The more troubling one is what we're seeing, inadequate investigation used to be number 3. It's now gone up to number 2. Let's blame that on technology. Now you have a client sending you a text saying, I'm thinking of doing this. And of course, you hear LawPRO saying communicate, communicate, and so you text back, say, yeah, great idea. You just gave an opinion in 140 characters. Can't happen. Don't have enough questions, haven't asked for enough information. So we're very concerned on that. Time management also may have been affected by the courts being closed down. So that's good, an overview of basically what we see, what we're seeing, and I'll pass it now to Sophia to speak to you about social engineering.
Well, you did that really quick. All right, social engineering. So, fraud. I think we're all terrified of fraud. Fraud continues to rise. It's tripled since 2017. And you can see on your screen there's different types of fraud. I'm not going to go through all of them. Some of them overlap, but we are going to talk about social engineering. So we'll start with what is social engineering. And we're going to talk about specifically in terms of your policy, and so the definition you see up there is not in the policy. There's a much longer, more in-depth definition. But in layman's terms, social engineering is when someone has manipulated you or coerced you, manipulated you into divulging confidential information or transferring assets. It's usually money. So a perfect example of that is you get an email from your client, maybe it's a real estate client, maybe it's a family law client, and the client says, I'm excited to get my funds next week. I have consolidated my bank account, and this is my new banking information. Please confirm that this is where you'll transfer the money. You get the email, you look at it, and you're like, okay, well, it's from the client's email, actual email address. They even refer you to the way they always do, and they sign off the way they always do, and you're like, okay, yeah, this is legitimate. And whatever transaction closes, whatever you have to do, you transfer money, client calls, and this is, by the way, I'm not making this up. This is actually a scenario, a real case. Client calls and says, I didn't get my money. And of course, at that point, the lawyer's like, well, you sent me that email. This is where I sent it. It was sent to a fraudster. Okay. Why does fraud happen? So, human characteristics. I'll give you a second to read through those. So, as humans, and I guess this can apply to you, the victim, it could apply to the fraudster, we all want more money, we want to trust, we're fearful, sometimes we don't take that extra step, and so forth. There's different forms of social engineering. So I love this slide. This is actually a Ray's slide. Phishing, smishing, and vishing. Try saying that really fast 3 times. Phishing is usually via email. Smishing is text, like SMS. And vishing is voice calls. So when you get that call, you owe $1,000 on your Visa, press 1 or whatever. I hope nobody actually presses 1. Okay, let's talk about your policy. But before I talk about your policy, so your 2024 policy has a sublimit coverage for social engineering fraud up to $250,000. But you can take steps to increase that coverage up to $1 million. I'm not talking about buying more insurance, I'm talking about just taking steps. We put out something called Social Engineering Toolkit. There's a video of me talking about exactly this, and there's some information that you can download and so forth. How many people saw that? All right, that's more than usual. I've been in a room of 175 people, and nobody put up their hand. I was a little scared. Okay, so then let's go through it. So again, your coverage is up to $250,000 for social engineering fraud, but you could increase it to $1 million by taking a few steps. There's 3 steps. This is step 1. The first step is all about the retainer agreement or the written agreement between you and the client. You don't need to write this down because it's in your materials, but also it's on our website that walks you through. It's much slower than what I'm doing now. So step 1, In your retainer agreement between you and the client, you want to include something about receipt, release, and transfer of funds. So, where are they going to transfer you money, and where are you going to transfer them money and how? B, you want to tell the client in the retainer agreement that they should not expect revised instructions about your trust account ever. And C, if they do, they should call you. This is the educational component of the retainer agreement. You're telling the client, this is my trust account information, you're only going to send me money via wire or certified check or whatever. However, and if you ever receive something from us saying our trust account information has changed, then you should call us and verify that. Step 2, if the client writes to you or contacts you and says, my banking information has changed, like the scenario I gave you, then you have to verify that independently. Or they call and say, or they write and say, my contact information has changed. So what does that mean, verify independently? So in my scenario that I gave you, if the lawyer had picked up the phone and called the client, so not write back in the email, because obviously that's not going to work, then that would satisfy the requirement. Or you could jump on a video call with your client, or virtual. Now, that only works if you've already verified their ID previously. Or you invite them in, so you can meet them in person and confirm that they actually gave you these revised instructions. And 3, maintain any updated information in writing. So anyone who picks up the file, or you pick up the file, you know exactly what happened and when. Now, just going back for, no, oh my God, geez, what am I doing?
There you go.
I know, I got ahead of myself. Just going back to 1 here, include written instructions in the retainer agreement about receipt, release, and transfer of funds. Well, you don't need to worry too much. We've provided example retainer language that you can take directly and put into the current retainer agreement you use, or you can tweak it the way you like. And that's downloadable in Word and PDF, so it's easy to use and tweak. Okay, some FAQs. I'm just going to check on the time here. All right, I have time. FAQs. I've had, we've had lawyers that'll call and say, well, I'm not comfortable putting my trust account information directly in the retainer agreement. I don't want it to be just floating out there. I think, Ray, you always say that's already kind of floating out there, right? Depending on the number of transactions you do, it's out there. However,
you send them checks. They have the information, so.
Yeah,
And if you don't want to do it in the retainer, do it separately. Do a separate letter, give them a piece of paper, just somehow give it to them in writing so that they have it. And at earliest, the important thing is that earliest possible in the relationship. So the fraudsters have less time to get in between you and the client. That's the concept here, is to have that exchange. And also for the client, because as you say, when you're sending money to the, and it's not just the trust account, but also the general account. Because if you send a bill, and we've had a lawyer report to us that the client, they sent the client the bill, and the client said, well, I paid it 2 days ago. What do you mean paid it 2 days ago? They'd received an email from the lawyer saying, here's my bill. They sent the money. It went to the fraudster. So who's missing the money at this point? Are you going to get paid at that point? So we need to exchange the account numbers for the general account and the trust account, and get the client's account also. Because this happens. We had one lawyer sent out $3.8 million to fraudsters.
recently.
A sole practitioner, $1 million coverage. He had stronger language.
Yeah, and some of that was recoverable, but the other, a big chunk of it was not. So if you continue to feel uncomfortable putting your account information, or the client doesn't want to give it to you right up front, you could put something else to replace that type of language, and you could put something like, banking information will be exchanged during our first meeting. Banking information will be exchanged, well, not exchanged during the first meeting. It'll be exchanged via email in the next 24 hours, and they'll be verified during our first meeting, or when ID verification is done. So you've put something in that's telling the client, I need your information, here's my information, and then we're going to verify it. But try to do it as early as possible, as Ray said. My clients only send me payment for fees. Do I need to take steps? So Ray touched on this. If your fees are lost, your fees are lost. You're not going to be able to recover that from your client. I mean, client's not going to pay again, so you're out of luck. I've had people say, like, well, I don't really send that much money, I only send up to $250, so do I really need to do this? It's really a risk management question. Do you want to be covered up to $250, or do you want to cover up to $1 million? That's a decision you can make. But remember, if you're only covering up to $250, it's per claim and in the aggregate. So be mindful of that.
And the important thing about why your insurance coverage has gone down is because this is not really an insurance matter. This is an education matter. We could leave it at $1 million, but of course your premium's probably going to go triple because the fraudsters will know it and the fraudsters will use it. And so luckily you are here, you get the message. There's a lot of people out there that still don't have the message. And so that's why we're trying to tweak the emphasis on education by bringing people in and they have an impact. And again, you don't have to do any of this. If you're satisfied with $250,000 coverage, that's fine with us. But we're just offering to be able to maintain what you have.
Do you need to submit anything to LAWPRO? No. It is on a per file basis. So if there are 300 files you worked on and you did it for $299, but you didn't do it for the one, and that's the one that, there's a claim, well, then you're covered up to the $250 for that one file. So you don't have to submit it. But if you have a question, just say you've tweaked the retainer language or the sample retainer language that's on our website and you want us to take a quick peek at it, sure, we could take a look at it. So do ask questions. On the social engineering toolkit, and I'll just show you what it looks like. So when you go to our Practice Pro page, this is what it looks like. It has a video and it has some downloadable material. There is a wiring funds checklist. We've had the question asked, is this mandatory to use as part of getting the coverage from $250 to $1 million? You don't have to use it. It's still a great checklist. It's been around for a long time. Before I started, but yeah.
It's a great exercise for staff to go through right at the beginning and put it in there, and then you have it in the file, so anybody needs to verify the account number is there. You can verify how it was verified, so it's just a checklist that's available.
All right, I showed you this already. So kind of some key points. Our campaign, Call Before You Click. I think we live in a virtual world. We do a lot of things via email all the time. But if we picked up the phone more often and we met our client either virtually or in person, we'd be able to catch a lot more fraud, right? Just by picking up the phone and saying, did you send that email? Did you send me this text message? Did you send me, did you leave this voicemail? Whatever it is. Training your lawyers and staff, so we know the buck always stops at us, but we need our staff to help us survive the day. So, but if they can catch it somewhere, then at least that gets nipped right there. But they won't know what to look for if they're not trained.
We had a lawyer report that they dealt with on commercial transaction. Dealt with a certain lender all the time. They've discharged mortgages and so on. So they've sent the request for discharge statement by email. They got the discharge statement by email. In this transaction, they got it. The lawyer looked at the discharge statement, was happy with the amount, and gave it to the clerk and said, "Here, send the payment." And the clerk noticed that they had changed the provision from sending a check by courier to a wire. She was just curious, so she called her contact at the lender that she dealt with normally and said, "I see you changed your payment method." And the lender said, "We haven't changed our payment method, and we didn't send you a discharge statement." So that's how sophisticated these guys are getting. It's not just an email, it's a document. The documents look they pick them up off the website. Clients have reported getting letters from their lawyer on the lawyer's letterhead. They are getting masters at replicating some very real-looking documents. And so that's the concern, is that you just can't rely on what you have. And that's why it's very important to be able to make that connection and let clients know. More and more we're finding now is that clients are being duped. The lawyers are being a little more astute about it, they're educated, their staff is educated, but the clients aren't. And a study I just saw the other day, over 50% of the public don't know about wire fraud. They just don't appreciate that risk. So it's on us not just to educate our staff, but to educate the clients also.
All right. So that wraps up social engineering. Administrative dismissals resume on Monday. I think everybody knows this, but as Ray said, we're still getting claims coming in, and a lot of it's just lawyers suddenly realize nothing's happened on the file, and they realize there's this deadline for Monday, and they're panicking, for lack of better words. There's an article on our Practice Pro website. It was written in February. It was updated yesterday. So please take a look. It goes through what is administrative dismissals, what can you do, and when you should report to LAWPRO. Is there anything you want to touch?
As we understand, the local court personnel will be in charge of dismissals that occur as of today and in the future. They're dealing with what's current. There's supposedly a team be assembled in Toronto that basically will deal with all of the backlog in every jurisdiction. And we don't know how big the team is. We don't know what their timing is. We don't know how they're proceeding. We've asked them not to pick a jurisdiction and just flood that jurisdiction because then it just becomes impossible. We tried to warn them that, they go too quickly on this, they're going to flood the courts with motions. And so we're trying to appeal to them to go easy on this. We don't know how long the team is in place for. We are told there may be something like 100,000 of these actions out there. So there's a number of it that's going on. And so we're very concerned because if we get a tenth of that, we're going to be swamped with the number of claims. So we're kind of concerned, but we are getting a number of claims now, people who are, and basically the direction is that if you have a consent timetable that you can submit with a court order, then that's great. You just submit it. We understand that if you submit that or you submit a motion for a status hearing, that will remove you off the dismissal list, and so it won't be dismissed pending that resolution. If you can't get the other side to agree, they say they're going to oppose or they're not, at least not agreeing with you, then you bring the motion. That takes you off the dismissal list, but then at that point we ask you to report to LAWPRO. We'd like to be able to see in the past, a number of lawyers have tried to fix things. Some have great affidavits, some not so great. And so that's what we try to do, is make sure that the materials are there. So typically you get one kick at the can, and we try to make sure that we have the best kick at it. So we're there for you. Please go in. If you don't think you have a claim but you have a question, practicepro.ca, you can send in a note. Sophia and I are monitoring that email, and we will respond to you and be able to answer any questions you have. I think that takes our presentation, and open to any questions that you may have. Scared him into silence.
When I do the social engineering presentations that I've been doing, around Ontario, Ray has been doing some too. We usually do two topics, social engineering being the first one, and then the second. I like mental wellness as the second, for obvious reasons, because we go through the stressful stuff first, and then we talk about mental wellness. So, the offer to come out to your region is still out there. We like doing it in person, so if you can get your members together to come agree on a date, then myself or Ray can come out and talk about social engineering, because it directly impacts their policy, but other topics too: file retention, mental wellness, administrative dismissals, so that's probably a little late. What other topics do we talk about? ID verification. Yeah. Still no questions?
Oh, yep.
This is sort of a law society, but also a LAWPRO question. We've been talking about the graying of the bar for years. And one of the consequences of the graying of the bar, particularly in more underserved areas, are senior lawyers who have been practicing for a very long time, and you notice a sudden decline in their ability to be handling files, or they're less out there. And as a president who has received reports of such an individual, what is our role first as the council who encounters the issue, or if you've been had it reported to you in a capacity as an association president? What steps does that lawyer take? Because you're about to possibly cut off many relationships and all sorts of things. So it's a very sensitive area to step into, but it's one that I'd really love to have some guidance on.
Yeah, that's, I would say, more of a law society issue. LAWPRO can deal with the after effect, the claims. We have no authority to step in to audit or not. That would be the law society's role. Unfortunately, as I understand it, if you send in a letter to the law society to say, I think, you know, you should investigate this person, they can go in and close down their practice and take it over. But as I understand it, you're going to be personally identified to that individual. So yeah, it does weigh on it, and that would be something to take up with the law society to deal with. Yeah.
Yesterday when Diana was here, she was telling us about the sole practitioners meeting. I think it's an administrator, they're called. If you die or something, you've got to have somebody appointed. That's just going to be part of standard practice coverage, I assume, if somebody's doing that, whether it's retainment or just be a good individual.
So on the administrator, we're just seeing it ourselves now. So as I understand it, your function is going to be advise the law society, advise the clients, and put out the, you know, hand out the files. To that extent, I don't see much liability for lawyers, as long as it's done on a fairly quick basis. 2 years later may be a little problem. But now, if you, as part of your agreement, take over that practice, at that point, they become your files. And so it's part of your practice and you would be covered by your insurance. If you did discover in taking over somebody's file that lawyer had missed something, then you want to get a claim in as soon as possible to LAWPRO to say that, you know, the previous lawyer missed something, so that it's tagged to them as opposed to the lawyer who's taking over. Little problem. Well, yeah. So that would be I think my tweak on it. As I say, we're looking at the program now. We may have something more formal going out, but at this point, I don't see any lack of coverage that lawyers would have.
Okay, if there's no other questions, I'll just wrap up here. Just a reminder to you, and then please remind your members that we have practicepro.ca. Our website has checklists and precedents and things that are useful, and we update it regularly. Our Avoid a Claim website is a blog website where you'll see short pieces like trust reporting and vacant home tax and things that, you know, are new and upcoming. And you can also subscribe, that way you get an email alert. We just released our new magazine in March. It's all mostly about fraud. You can't see it here, but it's super cool. If you actually download it, that man moves and like disappears, it comes back. So just go download it just to see that. And then we have these fraud fact sheets, and there's some out there too that are great for staff to educate them. And that's it. This is us. If you want to reach us. We are on social media and Instagram. I don't think Rory cares so much for Instagram, but we are on Instagram. And I say this because I know, you know, as lawyers, we get a lot of, I don't know what happened there. We get a lot of emails, but social media is a great way to kind of get short pieces of information. Like on Instagram, they're 15 to 30-second clips, and you can see something. Sometimes it's comical, so you could laugh at us or with us or whatever it is, but at least you can see what we're posting about, and then if it's information that you want to go, you can click and go to the more substantive material. So it's another way of receiving information. That's it. Thank you so much for your time.